You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 69, Trademarking Your Product, Picking a New Name. My name is Dr. Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com. That's D-I-A-M-E-N-T, patentlaw.com. Or if that's too hard to remember, you can get to it through patentingforinventors.com. That's patentingforinventors.com. Or call me at 424-281-0162. And while most attorneys can only practice in states where they are members of that state's bar, patent attorneys are actually allowed to practice patent law in any state, so feel free to contact me regardless of where you live. After going over my episode from last week, I feel like I probably jumped the gun on a few things. I know that I don't want trademarking to be a big part of this podcast, and I talked about last week not picking a name that's just descriptive, but it's at least suggestive of what your product is. But I didn't really go into why you would even want to register your trademark. So let me take a step back and talk about registering your trademark. Now, whenever you start using a name for your product, as long as that name is more than just a description, or sometimes even if it is, you're using that name as a trademark, which means that people associate that mark with the origin of the goods, and that's your business that makes the product. You don't need to register a mark to have some rights. As soon as you start using it, you have what are called common law rights. The thing about common law rights is that you only get rights to the geographic region where you're using them. So if you're selling your product only in Los Angeles and it's called the bumpler, let's say it's a stapler that works by bumping it, I'm just making that up, you would only have rights to stop other people from selling their product in Los Angeles or the surrounding areas, or where you would reasonably be expected to extend your geographic region. If someone starts selling another product called the Bumpler in Phoenix, Arizona, there is nothing you can do to stop them. With common law trademarks, you can only sue local businesses from using your identical or similar mark that would confuse customers. But most people want to sell their products all over the United States or all over the world. So common law trademarks probably aren't the best thing for you. Once you start using your mark, even if you don't register it, you should still put a TM symbol by it. This is different than the R with a circle around it. An R with a circle is a mark that can only be used if your mark is registered. So you can see that you're limited with just a common law mark because you can only stop people in your geographic location from using it. If you get a registered mark, you can stop people from all over the United States from using it. You have nationwide protection. Another advantage with a registered mark is that it's easier to sue people for more money if your mark is registered, because if you have a registered mark, you can get what are called statutory damages. This means that you don't actually have to prove that you lost profits. You just have to show that someone used your mark, and you can recover some damages. And there's some other ways to increase the amount that you get if you can show that the other party willfully infringed your trademark. This really goes beyond the scope of what this short episode is about, though. If you only have a common law mark, so you didn't register it, you actually have to prove that you lost profits due to someone using your mark, which can be a pain because it can be difficult to show that you actually lost profits due to someone else using your mark instead of losing profits due to some other reason, like maybe people weren't interested in your product anymore, or you stopped advertising. But the main reason that you want to register your mark is for nationwide protection. Now, in order to get nationwide protection, you have to sell or do something with your product that crosses state borders. This is one of the hurdles you have to overcome. So as long as you sell your product in 2 states, you can register your mark so that no one in any state can use the same mark. If you don't have your mark registered, you will only have common law trademark rights in probably just those 2 states where you sell your product. So nationwide trademark protection and being easier to sue someone for using your mark are the 2 main reasons why you'd want to register your mark. So in the last episode, I talked about picking a name that is at least suggestive. You don't want a descriptive name, and you might want a name that is arbitrary or fanciful. Now, also since the last episode, I remember I had my daughter talk about trademark names of her toys, and even did an errata at the end of it. But I have to do an errata on the errata because she showed me her toys, and apparently Pick Me Pops look like popsicles, and I guess you pick them. So at first I said it was arbitrary, then I said it was fanciful. But now that I see what they are, Pick Me Pop is actually probably suggestive. And this goes to another point. The type of trademark you have depends on the class of goods that it's marking. So if Pick Me Pops were the name of a new TV brand, then yeah, it would probably be fanciful. But for the name of a toy that looks like a popsicle, it's probably more suggestive. Now, it reminds me of a talk that I gave once, and someone asked me a question. It said, can you trademark a number? And my first reaction was, no, you can't trademark a number. And then he said, well, what about Google? Google is a number. It's a one with 100 zeros after it. Now, I thought about it and said, well, Google is spelled differently than the number Google. Google, the company, is Google, and the number is Googol. But when I thought about it more, I probably should have answered his question with another question. Should you be able to trademark a fruit? Now, you might think no. But what about Apple? They trademarked a fruit, Apple computers. But this is very important about trademarks, is that you only get trademark rights for the class of goods that you're using them for. So Apple has the trademark rights for the name of the fruit as it relates to computers, and probably some other stuff that are, computer related. Google has rights to the name Google when it comes to search engines, and I'm sure some other things related to computers as well. But it doesn't stop people from ever using the word Apple or Google. It only stops people from branding their own goods, Apple or Google, in the classes that Apple and Google have registered it for. This all probably should have been talked about in my last episode, but hopefully I've cleared some things up about trademarks. So now I can get to what today's episode is supposed to be about, and it's about not picking a name that someone else has. What you want to do is a trademark search. And let's just talk about U.S. trademarks. You'll want to go to the United States Patent and Trademark Office TESS database, that's TESS, and this is it stands for Trademark Electronic Search System. You can get there from a Google search, and I'm just going to talk about word searches. You can also search for logos or trademark designs, but to keep things simple, I'm just going to talk about a word search. Once you're on the website, you have the option of doing a basic word mark search, new user, a word and or design mark, structured, or a word and or design marked freeform. Now, to keep this really simple, we're just going to do the basic word mark search, new user. Once you do that, you'll get to a new page, and there are going to be some options, but I'm not going to change any of the options. And for example, let's say you thought you came up with a new toy and you want to call it Shopkins. So in the search term, you type Shopkins, then you click Submit Query. And when I do that, I see 9 entries. You'll see a table, and one column is serial number, one column is registration number, another column is marked name, and you'll see another column that says live or dead. If you see a serial number but no registration number, it means there's an application on file or it's been abandoned, but it hasn't been registered. For Shopkins, there are a few. One of them has a serial number. It's 4528193. And you can click on all of these. If you click that one, you can see that there's a Shopkins mark registered for goods having to do with a lot of crafts and toys. If you look at the one having serial number 5051992, it's a Shopkin mark having to do with cosmetics, helmets, bicycles, and some other things. So if you were to try and register Shopkins for any of these kinds of things, you're going to get rejected. So it's better to pick another name. But let's say that your product was computer printers and you want to call it Shopkins brand. You might have a chance of getting that allowed because it's an entirely different class of goods. And the issue is going to be whether there's any consumer confusion. Is someone going to think that the toy company started making computer printers? Probably not, but you never know. Someone might argue that. You do have to worry a little bit about famous marks, even if they're in a different class. I can't just call my computer printers Rolls-Royce computer printers, even if Rolls-Royce doesn't make computer printers. And that's because Rolls-Royce is a famous brand, and famous brands get some extra protection. But for the most part, you want to think about whether the goods and services that will have the mark on it will confuse an ordinary consumer for people shopping for those products into thinking that your goods and services come from somewhere else. So we did our search and found out that it's probably a really bad idea for you to try to name your own toy Shopkins because it's going to get rejected because it already exists. But what about similar marks? What if I want to name my product Chopkins, not Shopkins, but Chopkins with a CH? And I'm going to bring in my daughter, who is still on spring break, and see what she thinks about things. So do you think that someone should be able to name their product Chopkins?
No, because if you say Chopkins, really fast, they might hear Shopkins, so I don't think so.
What do you think it would confuse some parents if they're shopping for toys for their kids? If you told mommy, hey, can you get me Shopkins, and she saw something called Chopkins, you think maybe she'd get it by accident?
Yeah.
Yeah, probably. So it probably would confuse an ordinary consumers. So trademarks can get rejected if they're similar and not even identical. What about if there's something called Chop Kits? You think that should be allowed?
I really really don't know.
Yeah, it's a little bit tougher because there are more differences.
Because chop kits, like you could be like, I'm like a chopping kit.
Yeah, but what if it was a toy called Chop Kits?
I don't know.
What about chopping bins?
I think that would be allowed.
You think that's allowed? It's enough difference?
Yeah.
All right, so it's kind of a gray zone for some of the names, but you do want to be aware of if there are any similar or identical marks. But what if you had never heard of Shopkins and you entered in your search CHOPKINS in TESS and nothing shows up and you think you're okay to file Chopkins? How are you to know that there was something similar? Now, this is where different kinds of searches are helpful. You don't have to just enter in actual letters in your search. You can search by wildcards, by an asterisk or a question mark. If you want to search both Shopkins and Chopkins, by doing a question mark and then Hopkins, you would be conducting a search for any letters before Hopkins. And if you had an asterisk, it would search for multiple letters before Hopkins. And this can get really challenging because there's so many variations. What if there's a trademark for Shopkins with an M instead of an N? Then you probably would also get rejected. But if you're not searching right, you might miss that. So you can try searching for all the different variations that you think might pose a problem. And I suggest that you do this to start with. But this is where attorneys and trademark search companies come in handy. There are whole companies where their sole purpose is to help you search for trademarks that might cause you problems. The search company would likely give you a list of the most problematic terms, but aren't going to give you an opinion about it. But an attorney can look at this list and give you an opinion on the likelihood of allowance and give you some strategy going forward based on how similar the names are and the goods and classes that they're in. It's probably better to pay a couple $100 to a couple $1,000, depending on the type of search you want, to figure out a name, than to do your own search and, you do all this branding, then all of a sudden you get a cease and desist letter and a lawsuit because your name is too similar to someone else's. It might cost you hundreds of thousands of dollars to rebrand your product when you could have avoided that whole mess just by having someone do a proper trademark search for you. This can get extra complicated when you try searching international marks and common law marks, which aren't going to be on trademark websites, and website domain names. But I just wanted to give you a taste of the first steps you should take yourself to make sure that at least someone doesn't have the exact mark that you want or some close variation that you can think of. Next week will probably be the last episode on trademarks for a while, where I'll go into how to actually register your trademark. If you want help with your patent application, trademarks, responding to rejections, appeals, or anything else related to your invention, you can contact me through my website at patentingforinventors.com. That's patentingforinventors.com, or call Diamond Patent Law at 424-281-0162. I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com. Or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.